Welcome to Employment and Labor Law. My name is Scott Haddock, and this is Legal 267 at Edmonds College's ABA-approved paralegal program. So up to this point in the course, you've been learning legal rules. Now you're starting to use them, looking at real workplace situations and asking, how would the law actually analyze this? This week, we move into one of the most important and most practical areas of employment law, discrimination. You'll see that the federal framework in your text is something that's used both in federal law and state law. You'll see these in chapters 6 and 8. But in these lectures, our focus is on how those concepts actually operate in Washington practice, where many of you will be working. In this first lecture, we're building the structure that will carry you through the entire week. Think of this as the blueprint. And once you understand how the pieces fit together, everything else becomes easier to navigate and much more meaningful. From there, we'll take that structure and apply it. We'll start with race discrimination and disparate impact, and then move to LGBTQ protections, and finally to religious accommodation and the procedural path these cases follow from intake through litigation. And by the end of these lectures, you should not only understand the law, but you should begin to see how these cases are actually built, analyzed, and moved through practice. Let's start with the foundation, how Washington law approaches discrimination at its core. Now, before we get into rules and frameworks, we need to understand something more foundational, what the statute is trying to do. Let's start with the statute itself, the Washington Law Against Discrimination, or WLAD, found at RCW Title 49, Chapter 60. It declares that discrimination is a matter of state concern and a threat to democratic institutions. Those are big statements. It's not casual language. That's the legislature telling the courts very directly that this law is meant to carry real weight. And then it gives courts a specific instruction. This statute must be liberally construed. In other words, when there's an ambiguity or a close question, the law should be interpreted in a way that furthers its purpose, eliminating and preventing discrimination. And that has real consequences. It affects how courts evaluate evidence. It affects how doctrines like causation are applied. It affects whether cases survive summary judgment. And it shapes how attorneys frame arguments from the very beginning of a case. So when you see Washington law providing broader protection or allowing more cases to reach a jury than the federal courts, that's not accidental. It flows directly from this statutory purpose. If you take one thing from this slide, it's this. The WLAD is designed to work. It's designed to reach real-world discrimination even when it's subtle, mixed with other factors, or difficult to prove directly. And that perspective will carry through everything we do in this lecture and throughout the week. With that purpose in mind, let's briefly anchor ourselves in the federal framework you're seeing in the textbook. So let's start with Title VII of the Civil Rights Act of 1964. This is the foundation of federal employment discrimination law. It defines the core protected classes: race, color, religion, sex, and national origin. Those categories determine what types of claims may be brought. From there, the law is organized around two primary theories. The first is disparate treatment. Disparate treatment is intentional discrimination. This theory asks whether the employer acted because of a protected characteristic. The second theory is called disparate impact. This is based on the effects of discrimination. It looks at whether a neutral policy produces unequal outcomes across groups. And then there's the McDonnell Douglas framework. This is the burden-shifting structure used when there is no direct evidence. The employee raises an initial inference, the employer provides a reason, and the analysis returns to whether the explanation by the employer holds up. And that is the baseline. It's how discrimination law is structured at the federal level and how it's introduced in your textbook. But for our purposes, We're not reteaching those concepts in detail. You should be working through those in chapters 6 and 8. Instead, what we're doing in this lecture is using this framework as a reference point. Because once we shift into Washington state law, you'll see something important. The structure remains familiar, but the way it's applied can change, sometimes more flexibly, and often in ways that allow more cases to move forward in state court. And with that federal baseline in mind, let's turn back to Washington state law, where most of your real-world work will take place. So now let's return to Washington state law and look at one of the most important differences between state and federal law, the scope of protection. Start with the protected classes listed on the slide. In addition to the familiar federal categories, the WLAD includes protections for marital status, sexual orientation, and it explicitly includes gender identity and gender expression. It also protects veteran and military status, as well as citizenship and immigration status. Now that alone significantly expands the reach of the law. Next, let's look at how some overlapping categories are defined. The WLAD includes creed. Creed is a broader category than the federal concept of religion and can extend to a wider range of belief systems and expressions. The WLAD also defines disability very expansively, covering sensory, mental, and physical conditions in a way that often brings more situations within the statute. So you're not only dealing with more categories, you're also dealing with broader definitions of those categories that were defined in Title VII. Now add one more piece, who the law applies to. The WLAD applies to employers with 8 or more employees. Title VII applies to employers with 15 or more employees. That means many smaller workplaces completely outside of federal law are still covered under Washington state law. When you put all of that together, the takeaway is clear. The WLAD is broader than Title VII. It reaches more people, more workplaces, and more types of claims. And that has a direct impact on practice. At intake, one of the first questions becomes, is this a federal claim, a state claim, or both? Because depending on the protected category and the size of the employer, Washington state law may be doing most or all of the work here. And this ties directly back to the statute's purpose. If the goal of the WLAD is to eliminate discrimination broadly, expanding both the scope of protection and the reach of the law is one of the most direct ways to do that. Now, so far we've looked at who is protected. Now we're going to turn to who the law actually applies to. As I just mentioned, under Title VII, an employer must have at least 15 employees. If the employer is smaller than that, federal law simply doesn't apply. Now, Washington state lowers that threshold under the WLAD to 8 or more employees. And that difference matters more than it might seem at first, because many businesses, especially smaller firms, local offices, and closely held corporations, fall into that 8 to 14 employee range. Those employers are completely outside of Title VII, but they're fully covered under the WLAD. So at the very beginning of a case, one of the most practical questions is, how large is the employer? Because that answer determines whether federal law is even available or whether the case will exist only under Washington law. And this is where your role becomes very concrete. Before you analyze evidence or apply any legal tests, you're helping identify which legal frameworks are even on the table in the first place. This also reinforces the broader theme we've been building. The WLAD is designed to reach more workplaces, not fewer. Now that we've looked at who is protected and which employers are covered, we turn to the most important doctrinal difference, and that's how these cases are actually decided. Determining how the cases are actually decided is really the center of Washington discrimination law, and it's one of the most important concepts you'll take from this course. Let's start with the standard itself. Under the WLAD, the governing rule is called the substantial factor test. What does that mean? We'll look first at what's required. Discrimination must be a real, meaningful factor in the employer's decision. It must be part of what actually drove the outcome. And importantly, it can be one of multiple possible reasons. And that brings us to what is not required. Under the WLAD, discrimination does not have to be the sole cause. It does not have to be the determining cause. And it does not have to meet a strict but-for causation standard. That's a very different question from what you'll sometimes see in federal law and other areas of this doctrine. We're not asking, would this have happened anyway? What we're asking under the WLAD is, was discrimination part of what happened? That shift may sound subtle, but it has major consequences, because in the real world, employment decisions are rarely clean. Employers often have multiple explanations, some legitimate and some potentially problematic. Washington state law is designed to account for that reality. If the evidence supports more than one reasonable interpretation, the case may move forward. And at that point, it is typically a jury, not a judge, that resolves those compelling explanations or competing explanations, In other words, mixed motive cases are not the exception, they're the norm. And that's not accidental. It ties directly back to the statute's purpose that we discussed earlier. If the law required discrimination to be the sole or determining cause, many real-world cases would never make it past summary judgment. So when you're analyzing a case under the WLAD, keep your focus here. Was the protected characteristic part of the decision-making process in a meaningful way? If the answer to that question is yes, then the analysis continues under the WLAD. Now let's see how this standard operates in a real case, because this is where the doctrine becomes much clearer. So let's bring the substantial factor test to life with a real case. The case is Scrivener versus Clark College. In that case, a 62-year-old part-time professor, adjunct professor, Catherine Scrivener, applied for a full-time tenure-track position at Clark College in Vancouver, Washington. She was not selected. The college explained its decisions in familiar terms. It said the selected candidate had more recent teaching experience and was, quote, a better fit, unquote, for the position. On the surface, that sounds like a legitimate, non-discriminatory explanation. And that is exactly how these cases often look. But the Washington State Supreme Court focused on a different question. Not whether the employer had a legitimate reason, but whether age could have been part of the decision as well. And the court said something critical. If the evidence allows two reasonable interpretations, one that the decision was legitimate and one that discrimination played a role, the court does not resolve that conflict. The jury does. That's the substantial factor test in action. The presence of a legitimate explanation does not end the case if there's also evidence that discrimination could have been meaningful as a contributing factor. This is what I sometimes think of as the Scrivener effect. In close cases, the decision shifts away from a single judge and towards a jury. And that really matters because it means employers cannot rely on general explanations like, quote unquote, better fit if the surrounding evidence suggests something more may be going on. The case shows how Washington law treats mixed motive situations. The existence of a good reason does not eliminate the possibility of an unlawful one. And as a paralegal, this is exactly where your work matters, where these cases rise or fall on the quality of evidence behind these competing explanations. Students sometimes ask me, well, then what happened in the Scrivener case? And what happened in the Scrivener case is because of that Supreme Court decision, it went back to the trial court, and before it could actually be litigated, the parties settled, the college realizing that it had made a mistake. Now, let's look at the opposite outcome. What happens when the evidence does not support that second inference? So now let's look at the flip side of the coin. In Mackey versus Home Depot, the plaintiff, Lori Mackey, was an employee with medical restrictions who had requested workplace accommodations, and she was later terminated. Let's start with what happened. The employer's explanation, Home Depot, was straightforward. She violated a safety policy by operating equipment she was not authorized to use, and that is a legitimate reason on this slide. At the beginning of the case, she was able to establish what's called a prima facie case, or prima facie claim. That means it's enough initial evidence to suggest that discrimination might have occurred. But that's only the starting point. To move forward, she also had to show pretext. In other words, she had to present evidence that the employer's explanation was either not true or not the real reason she was terminated. And in this case, she was not able to accomplish that. The safety violation was documented, it was consistently applied, and it was supported by the record. There was no second competing explanation that suggested discrimination was also part of the story. So unlike in Scrivener, there was no competing inference. The court saw only one reasonable explanation, and that leads directly to the result. The case was dismissed. Now this is a critical contrast. In Scrivener, there were two plausible explanations, one being discrimination, and the case was allowed to continue. In Mackey, there was only one, and it was not discrimination, and so the case was not allowed to continue. There was nothing for the jury to decide. There is also a second lesson that you should take away here. The court emphasized that the accommodation process is interactive. Both the employer and the employee have to participate. When that process breaks down, the claim often becomes much harder to sustain. And this ties back to how these cases are built. Prima facie gets the case moving, but pretext is what really gets it to the jury. So now that we've seen both outcomes, let's organize them into a framework you'll use to analyze every discrimination case in Washington. Now let's organize what you just saw in those two cases into a framework that you can apply moving forward. This framework is called the McDonnell Douglas framework, the structure that courts use to analyze discrimination claims when there is no direct evidence. Washington uses the same three-step structure that the federal law uses, but with an important difference in how it's applied. Applying the McDonnell Douglas framework, we start with step one, the prima facie case. This is the threshold. It's the minimum evidence needed to suggest that discrimination might have occurred. If the plaintiff cannot meet this initial step, the case ends immediately. Step two is where the employer provides a legitimate, non-discriminatory reason for the firing decision. You saw that in both cases. Remember, better fit in Scrivener, safety violation in Mackey. Then we move to step three, pretext. This is where most cases are won or lost. Pretext asks whether the employer's explanation holds up, whether it's consistent, supported, and applied fairly, or whether it begins to break down under scrutiny. This is also where the burden shifts back to the plaintiff to challenge that explanation. Now connect this back to what you just saw. In Scrivener, the plaintiff was able to challenge the employer's explanation. In Mackey, the plaintiff could not. That difference happens at step three. And this is where Washington state law makes a meaningful difference. At this stage, the substantial factor test applies. The plaintiff does not have to prove discrimination was the only cause in Washington state, just that it was a meaningful contributing factor in the decision. This is why most cases in Washington survive and reach a jury. Because the question is not, was this the only reason? It's, is there enough evidence for a reasonable jury to find that discrimination played a role? And that brings the entire framework together. Prima facie gets the case moving, pretext is what gets it to a jury. Because at the end of the day, Everything in the structure is building towards one question. Does the evidence support a reasonable inference that discrimination played a role? And if it does, the case continues. That naturally raises the next question. What type of evidence actually supports the inference of discrimination? So now we get to the question that actually drives these cases in practice. What does the evidence look like? Because at this point, we know the structure. We know the legal standards, but cases are not one on structure, they're one on evidence. And in most situations, that evidence is not direct. You're almost never going to see a clear statement of discriminatory intent. Instead, these cases are built through what's called circumstantial evidence, pieces of information that, taken together, support an inference of discrimination. And one of the most important types of circumstantial evidence is comparator evidence. This is where you look at similarly situated employees, people doing similar work under similar conditions, and you ask whether they were treated differently. Another key category of circumstantial evidence is inconsistency. If the employer gives different explanations at different times, or if the explanation does not match the record, that can suggest the stated reason is not the real reason. Timing also matters. If an adverse action happens very close in time to a protected activity or status becoming relevant, that timing can support an inference of discrimination. And in some cases, you begin to see broader patterns, whether through repeated outcomes or statistical disparities, that introduce the idea that something more than a coincidence is at work here. What you're doing, piece by piece, is building a story. Not a perfect story, not a certain story, but a plausible story. One that allows a reasonable decision maker, like a jury, to infer that discrimination played a role. Now, up to this point, everything we've discussed assumes one key thing, that the case is about intent. But not all discrimination cases work that way. So up to this point, everything we've discussed has assumed one thing, that discrimination is about intent. We've been asking, did the employer act because of race, age, or some other protected characteristic? But not all discrimination works that way. Sometimes the employer's policy is neutral on its face. It applies to everyone the same way. And yet, in practice, it produces very different outcomes for different groups. And that's where disparate impact comes in. Here, the focus shifts completely. We're no longer asking why the employer acted. We're asking what the employer's policies actually do. And importantly, intent does not matter here. A policy can be lawful in purpose, but unlawful in effect. And unlike everything we've discussed so far, these claims are often built not on individual comparisons, but on data. So as we move into the next lecture, we're going to take this concept and build it out, looking at real examples, evidence, and how these claims, disparate impact claims, are proven in practice. So while the McDonnell Douglas framework gives us the structure, the real battlefield in these types of cases is often summary judgment. Think of summary judgment as the gatekeeper stage. It applies regardless of the theory, whether it be intent or impact. The employer asks the judge to dismiss the case before trial, arguing that there is no genuine issue of material facts for the jury to decide. Think back to our two cases. In Scrivener, the Washington State Supreme Court held that the evidence supported two reasonable interpretations, one legitimate, one discriminatory. And because of that conflict, the judge could not resolve the issue. That decision was sent back to the jury. In Mackey, the plaintiff could not produce that second interpretation. The employer's explanation stood on its own. so there was no factual dispute for a jury to decide, and that case was dismissed in summary judgment. And this is where your role as a paralegal becomes critical. During discovery, you are not just gathering documents. You are building the factual record that creates that genuine issue. Emails, inconsistencies, comparator evidence, those are what keep the case alive. And at this stage, the judge is not deciding whether discrimination occurred. The question is whether a jury could reasonably find that it did. And because of the substantial factor test, Washington law makes it harder to dismiss these types of cases. If the evidence supports a meaningful inference of discrimination, then the judge must allow the case to move forward. This is called, I would call this at least, the Scrivener's effect. In close cases, the decision shifts from a judge to a jury. But not all discrimination cases arise from a single decision. Sometimes it develops over time through the conditions of the workplace itself. Now, so far, we've been analyzing discrimination through discrete decisions: hiring, firing, discipline, using the framework and evidence that we've been discussing. But discrimination does not always appear as a single decision. Sometimes it develops through the environment itself. And that's where hostile work environment claims come in. Instead of asking what decision was made, we shift to a different question. What was it like to work there? At its core, the claim asks whether the workplace has become abusive through conduct or conditions. And as before, the conduct must be tied to a protected class: race, sex, religion, national origin, age, disability, sexual orientation, gender identity, gender expression, or any other category that's protected under the Washington state law. Now walk through the 4 elements with me. First, the conduct must be unwelcome to prove a hostile work environment. The employee, in other words, did not invite or accept the conduct. Second, it must be based on a protected class, and this is critical. The general conflict or poor management is not enough. It has to have something to do with a protected group. Third, the conduct must be severe or pervasive. And this is one of the most important distinctions, because a single extremely serious incident, such as a threat or physical conduct, can be enough, or it can be a pattern of smaller incidents that, over time, created that hostile work environment, that harassment. And fourth, the conduct must be imputable to the employer. Now, in practical terms, that means that the employer knew or should have known about the conduct and failed to take appropriate action. Courts then evaluate the totality of the circumstances. They do not isolate one comment or incident. They look at a full pattern: frequency, severity, and whether the conduct was humiliating or threatening, and whether it interfered with the employee's ability to work. So while this claim looks different from a hiring or firing case, the method is familiar. You're still building an inference from the evidence, but instead of comparing employees or analyzing a single decision, you're constructing a timeline of conduct that shows how the environment developed. And this is where your role as a paralegal becomes especially important. You're gathering emails, messages, complaints, and witness statements, and you're organizing them into a record that allows the court or the jury to see the full picture. And with that in mind, we can now step back and look at how these doctrines, these decisions, patterns, and environments all come together in a real-world litigation strategy. At this point, you've seen the structure, the evidence, and how cases succeed or fail. Now we step back and we look at how all of that turns into strategy. Start with the first point on the slide. In practice, attorneys often bring both Title VII and WLAD claims together in the same lawsuit. There's no requirement to choose one or the other, and including both can preserve options. But in Washington state, the reality is that the case usually is driven by the WLAD. And you can now see why. Look at the advantages listed on the slide. First, scope. The WLAD covers more protected classes than the federal law does. Second, coverage. As we've talked about before, the WLAD applies to smaller employers, down to 8 employees, while Title VII requires 15 or more. Third, causation. The WLAD uses the substantial factor standard that we've been working with. That makes it easier for cases to survive summary judgment and eventually reach a jury. Fourth, filing. Under the WLAD, a plaintiff can go directly to court. There's no requirement for exhausting your administrative remedies before filing a lawsuit like there is with the EEOC in Title VII. And fifth, remedies. Federal law caps damages, but the WLAD does not cap emotional distress damages, and it allows recovery of attorney fees. So now we move to litigation strategy. Attorneys also think about where the case will be heard. In Washington State Superior Court, a plaintiff needs only 9 out of 12 jurors to reach a verdict. But in federal court, the jury must be unanimous. That difference alone can shape how a case is pled. And this leads to venue control. Sometimes attorneys choose to bring only WLAD claims to reduce the likelihood that the claim might be removed by the defense to federal court. So when you put all of this together, you see the practical reality. The WLAD is often the engine that drives Washington state discrimination litigation. And this ties directly back to everything that we've covered. The broader scope, the lower coverage threshold, the substantial factor test, and the summary judgment standard, all of it works together to shape outcomes. So the question then shifts. You are no longer just asking, is there discrimination? You're asking which legal framework gives us the strongest path forward. And that's where legal analysis becomes strategy. Let's close by pulling all of this together and setting up where we're headed next. Let's step back and pull all of this together. And let's start with the big picture. WLAD is the primary framework in Washington. That's the law doing most of the work in these cases, from coverage to causation to strategy. Next, the key doctrine. That's the substantial factor test. It's what drives outcomes. It determines whether a case survives or ends, especially at summary judgment. Which brings us to the gatekeeper. Summary judgment is where the cases are won or lost. Not because the court decides what actually happened, but because it decides whether a jury could find that the discrimination played a role. And that leads directly to your role. As a paralegal, you're helping build the evidence that drives the case. You're organizing facts, identifying patterns, and developing the record that allows a court or a jury to see what actually happened. You're taking a messy, real-world situation and turning it into something that can survive legal scrutiny. And that's the shift this lecture is designed to make. You're moving from learning the law to beginning to use the law. In the next lecture, we're going to build on this foundation more, but we're going to do so we're not going to do so by relearning the framework. What we're going to do is use the framework. We'll focus on race discrimination and disparate impact, and we'll move from the what of the law to the how of the proof. We'll look at what the evidence actually looks like in practice, how comparators are used, how patterns emerge, and how, in some cases, data becomes the most important evidence in the case. And that's where this starts to feel less like a doctrine and more like real legal work.